IL Real Estate Exam Prep. Question 1. Quinn wants to pay a sponsored Illinois licensee, Blair, directly for help with a purchase. How should compensation normally be handled? Option A. The sponsored licensee should receive compensation through the sponsoring broker. Option B. The buyer may pay the licensee directly at any time. Option C. The title company must split the fee directly with the licensee. Option D. The licensee may accept a secret bonus if the transaction closes. The correct answer is option A. The sponsored licensee should receive compensation through the sponsoring broker. A sponsored licensee is normally compensated through the sponsoring broker rather than directly by the public. Direct payment, title minus company fee splitting outside the broker relationship, and secret bonuses create licensing, disclosure, and compensation problems. Question 2. Two firms agree that one will serve buyers only in Chicago while the other will avoid that area and focus on Springfield. Which antitrust concept best fits? Option A. Valid escalation clause. Option B. A market allocation. Option C. A leasehold estate. Option D. Statutory redemption period. The correct answer is option B. Market allocation. Competitors who divide territories or customers can create an unlawful market allocation scheme. Escalation clauses are contract tools, leasehold estates are possessory interests, and redemption periods relate to foreclosure law. Question 3. A seller receives $364,000 at closing, pays off a $76,000 mortgage, and pays $7,700 in seller closing costs. What are the approximate net proceeds? Option A. $288,000. Option B. $356,300. Option C. $280,300. Option D. $83,700. The correct answer is option C. $280,300. Seller net proceeds subtract the loan payoff and seller costs from the sale price. $364,000 minus $76,000 minus $7,700 equals $280,300. The other answers omit one deduction or add deductions instead of subtracting them from the sale price. Stressed about your CNA exam? We can take CNA exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. During a first substantial discussion, Rowan asks Jamie whether the brokerage represents the buyer, the seller, or both. Why should the relationship be clarified early? Option A. The relationship is irrelevant until after closing. Option B. A broker owes no duties until a deed is recorded. Option C. Agency disclosure is needed only for commercial leases. Option D. Agency and brokerage relationships affect duties, confidentiality, and the consumer's expectations. The correct answer is option D. Agency and brokerage relationships affect duties, confidentiality, and the consumer's expectations. Brokerage relationships determine duties such as disclosure, confidentiality, obedience to lawful instructions, and care. Waiting until closing, tying duties only to deed recording, or limiting disclosure concepts to commercial leases would leave the consumer without important relationship information. Question 5. Casey prepares a price opinion for a seller indicator to help set a listing price. Which limitation should be remembered? Option A. A CMA or broker price opinion is not the same as a formal appraisal by a licensed appraiser. Option B. A CMA always creates a guaranteed sale price. Option C. A broker price opinion transfers title. Option D. A CMA eliminates all disclosure duties. The correct answer is option A. A CMA or broker price opinion is not the same as a formal appraisal by a licensed appraiser. A CMA or BPO can help estimate market price for brokerage purposes, but it is not a formal appraisal. It does not guarantee a sale price, transfer title, or remove disclosure obligations. Question 6. A small rental property has annual net operating income of $37,000 and an indicated capitalization rate of 8%. What value is suggested by the income approach? Option A, $296,000. Option B, $462,500. Option C, $4,625. Option D, $231,250. The correct answer is option B, $462,500. The income approach using direct capitalization divides NOI by the capitalization rate. $37,000 divided by 8% equals about $462,500. The other answers multiply by the rate, treat the percent as a whole number, or cut the indicated value in half. Question 7. A buyer asks about a prior occupant died peacefully in the home, but there is no physical defect or legal restriction affecting the property. Why may this be treated differently from a material defect? Option A. Every rumor must be included in the deed. Option B. The broker must create a structural inspection report. Option C. Stigmatizing facts usually do not have the same disclosure treatment as physical or legal defects. Option D. The seller must lower the price by statute. The correct answer is option C. Stigmatizing facts usually do not have the same disclosure treatment as physical or legal defects. Stigmatized minus property issues generally differ from material physical defects or title/legal problems. Rumors do not belong in a deed, brokers do not create structural inspection reports, and statutes do not automatically set a required price reduction for a stigma. Question 8. A landlord uses a consumer credit report to evaluate Hayden's rental application. Which law commonly appears in property minus management screening questions? Option A, Truth in Zoning Act. Option B, Statute of Frauds only. Option C, Uniform Commercial Code Bulk Sales Rules. Option D, Fair Credit Reporting Act. The correct answer is option D, Fair Credit Reporting Act. Tenant screening that uses consumer credit information implicates the Fair Credit Reporting Act. The other choices do not specifically govern consumer reports used to evaluate rental applicants. Are you looking for CNA exam actual questions? Visit our website pokerexams.com to access CNA exam study guide with actual questions and answers. Scan the QR code or click the link in the description to get CNA exam answer key today. Question 9. A property is worth $331,000 and has a loan balance of $117,000. Approximately how much equity does the owner have? Option A, $214,000. Option B, $448,000. Option C, $117,000. Option D, $264,800. The correct answer is option A, $214,000. Equity is the property's value minus debt secured by the property, so $331,000 minus $117,000 equals $214,000. The distractors add debt, report the loan balance, or use an unsupported percentage of value. Question 10. A buyer is reviewing required environmental paperwork involving known underground storage tank concerns. Why are these disclosures commonly tested during Logan's Naperville rental duplex file review? Option A. They guarantee the property has no environmental condition. Option B. They help buyers evaluate known or potential environmental risks before becoming bound to the transaction. Option C. They replace the purchase contract entirely. Option D. They require the broker to perform engineering tests in every sale. The correct answer is option B. They help buyers evaluate known or potential environmental risks before becoming bound to the transaction. Environmental disclosure laws are designed to inform buyers about known or potential risks before or during the contracting process. They do not guarantee a problem-free property, replace the contract, or require brokers to perform technical engineering tests in every transaction. Question 11. Casey signs closing documents for an absent seller under a power of attorney. Which issue is most important? Option A. A power of attorney automatically makes the signer the owner. Option B. No written authority is ever needed. Option C. The authority must be valid and broad enough for the act being performed. Option D. The broker may create authority by verbal approval alone. The correct answer is option C. The authority must be valid and broad enough for the act being performed. A power of attorney gives authority only if it is valid and covers the act being performed. It does not transfer ownership to the signer by itself, and verbal approval alone is not a safe substitute for proper written authority. Question 12. A buyer purchases for $285,000, makes a 15% down payment, and has $3,600 in closing costs. About how much cash is needed at closing before credits? Option A, $42,750. Option B, $3,600. Option C, $281,400. Option D, $46,350. The correct answer is option D, $46,350. Cash needed combines the down payment and closing costs, 15% of $285,000 plus $3,600 equals $46,350. The other choices omit either the costs or the down payment, or subtract costs from the price incorrectly. Question 13. Reese and Alex both claim the same earnest money after a failed Illinois purchase contract. How should the broker view disbursement? Option A. The broker should follow the contract, written instructions, or lawful dispute minus resolution process before releasing funds. Option B. The broker may give the money to the latter party. Option C. The broker must always keep the money as commission. Option D. The buyer automatically receives the money regardless of contract terms. The correct answer is option A. The broker should follow the contract, written instructions, or lawful dispute minus resolution process before releasing funds. Earnest money disputes require careful handling under the contract and applicable escrow rules. A broker cannot choose based on pressure, convert the money into commission without entitlement, or ignore the party's contract rights. Question 14. A buyer and seller dispute whether a custom chandelier stays with the property. Which test is most relevant? Option A. Whether the buyer likes the item. Option B. Whether the item has become a fixture based on attachment, adaptation, agreement, and intent. Option C. Whether the item is expensive enough. Option D. Whether the broker wants it included. The correct answer is option B. Whether the item has become a fixture based on attachment, adaptation, agreement, and intent. Fixture analysis looks at factors such as attachment, adaptation, agreement, and intent. Personal preference, price alone, or the broker's preference does not determine whether the item stays with the real estate. Question 15. A rental property has NOI of $27,000 and a value estimate of $330,000. Approximately what capitalization rate is indicated? Option A, 4.1%. Option B, 11.2%. Option C, 8.2%. Option D, 12.2%. The correct answer is option C, 8.2%. The capitalization rate is NOI divided by value, so $27,000 divided by $330,000 is about 8.2%. The other answers have the rate, add unsupported points, or invert the formula. Question 16. An unlicensed assistant named Logan is asked to explain offer terms to a buyer at an open house. Why is that risky? Option A. Unlicensed assistants may perform every brokerage task if unpaid. Option B. Only title companies need real estate licenses. Option C. Licensed supervision converts negotiation into clerical work. Option D. Explaining or negotiating transaction terms can cross into licensed activity. The correct answer is option D. Explaining or negotiating transaction terms can cross into licensed activity. Unlicensed assistants may perform clerical or administrative tasks, but explaining terms, negotiating, or advising consumers may require a license. Being unpaid, supervised, or involved with a title company does not transform licensed brokerage functions into purely clerical work. Question 17. A buyer reviews debits, credits, lender charges, preparations, and cash needed to close. Which document function is being tested? Option A, settlement or closing statement accounting. Option B, a zoning map amendment. Option C, a subdivision plat approval. Option D, a deed covenant creating a life estate. The correct answer is option A, settlement or closing statement accounting. Closing statements organize transaction charges, credits, prerations, and cash to close. Zoning approvals, plats, and deed covenants do not perform the same accounting function. Question 18. Jordan signs an exclusive brokerage agreement and expects the broker to present offers and assist with negotiations. Which Illinois topic does this resemble? Option A, a deed restriction created by neighbors. Option B, minimum services and duties under brokerage agreements. Option C, a mortgage acceleration clause. Option D, a tax appeal before the assessor. The correct answer is option B, minimum services and duties under brokerage agreements. Illinois state minus specific outlines test brokerage agreements, exclusive agreements, and minimum services. Deed restrictions, mortgage acceleration, and tax appeals involve different legal concepts rather than brokerage minus service duties. Stressed about your CNA exam? We can take CNA exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks why a state real estate recovery fund might exist. Which purpose is closest? Option A, guaranteeing every buyer a profit on resale. Option B, paying all ordinary home repairs after closing. Option C, providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Option D, replacing the need for broker licensing. The correct answer is option C, providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Recovery funds are designed as limited consumer minus protection remedies for qualifying misconduct minus related losses. They do not guarantee investment profit, pay routine repairs, or replace licensing and discipline systems. Question 20. A managing broker supervising Harper discovers repeated advertising and trust minus account mistakes. Which responsibility is most directly involved? Option A, recording deeds for every buyer. Option B, issuing building permits. Option C, approving zoning variances. Option D, supervision of sponsored licensees and brokerage compliance systems. The correct answer is option D, supervision of sponsored licensees and brokerage compliance systems. Managing and sponsoring brokers are responsible for supervision, training, and compliance controls for sponsored licensees. Recording deeds, issuing permits, and approving zoning variances are handled by other parties or government offices. Question 21. A buyer pays for the right, but not the obligation, to purchase a property at a set price during a stated period. Which agreement is described? Option A, option agreement. Option B, open listing only. Option C, tax deed. Option D, subordination agreement. The correct answer is option A, option agreement. An option gives the holder the right to buy under stated terms without requiring the holder to exercise it. An open listing is a brokerage agreement, a tax deed relates to tax enforcement, and subordination changes lien priority. Question 22. A brokerage wants to operate a virtual office location for Illinois consumers. Which compliance focus best fits the licensing outlined during Drew's Galesburg rental duplex file review? Option A, avoiding all broker supervision because the office is online. Option B, registration, supervision, and public minus facing brokerage compliance for virtual or branch operations. Option C, replacing written brokerage agreements with website clicks only. Option D, advertising as an unlicensed technology company. The correct answer is option B, registration, supervision, and public minus facing brokerage compliance for virtual or branch operations. Virtual or branch operations still require appropriate brokerage supervision and compliance with licensing rules. Being online does not remove supervision, written minus agreement, licensing, or advertising requirements. Question 23. An ad states only a very low monthly payment without giving required credit terms or context, which lending minus advertising law is often implicated. Option A, rule against perpetuities. Option B, Fair Credit Reporting Act only. Option C, Truth in Lending Act and Regulation Z. Option D, Illinois Plat Act only. The correct answer is option C, Truth in Lending Act and Regulation Z. Regulation Z under the Truth in Lending Act governs many consumer credit advertising disclosures. The rule against perpetuities and plat laws do not govern loan advertising, and the FCRA focuses on consumer reports rather than payment minus ed trigger terms. Question 24. A licensee knowingly misrepresents a material fact to induce a buyer to sign. Which licensing consequence is most relevant during Parker's Quincy Suburban Ranch Home File Review? Option A, automatic zoning approval. Option B, mandatory title insurance payout. Option C, a tax prioration credit only. Option D, disciplinary action for unprofessional or dishonest conduct. The correct answer is option D, disciplinary action for unprofessional or dishonest conduct. Knowing misrepresentation can trigger discipline because it harms consumers and violates professional standards. Zoning approval, title insurance payout, and tax prioration are unrelated remedies for this licensing misconduct. Question 25. A seller receives an offer of $335,000 and responds with $338,000 plus a changed closing date. How should the seller's response be classified? Option A, a counteroffer that rejects the original offer and proposes new terms. Option B, a full acceptance of the buyer's original offer. Option C, a deed transferring title immediately. Option D, a lease option created by operation of law. The correct answer is option A, a counteroffer that rejects the original offer and proposes new terms. Changing material terms such as price or closing date creates a counteroffer rather than an acceptance. It does not transfer title, and it does not create a lease option unless the parties separately agree to those terms.